Welcome back to HOA Spot. I thought it would be a warning. It was a campaign. You picked the wrong person to push. That is what I said, standing in my driveway with a tape measure in one hand and a survey report in the other, while Laura Stewart screamed that she would freeze all approvals for my address until I learned respect. She was the records custodian for the Riverstone Meadows Association, which in Missoula, Montana, meant she controlled every document, every permit copy, every inspection record, and every piece of paper you needed to prove you were following the rules. And right now, she was waving a tiny line level at me like it was a smoking gun, her face bright red under her white sun hat, her red light jacket pulled tight even though it was pushing 90 degrees with humid heat shimmer rising off the asphalt. I work as a high school assistant coach, which means I spend my days teaching kids how to stay calm under pressure and follow the process, and my evenings reviewing game footage and answering parent emails. I moved to this neighborhood 2 years ago because the dues were reasonable and the rules seemed straightforward. The Riverstone Meadows Association was supposed to be a quiet place where contractors got harassed like criminals. But I did not know that detail until it was too late. Now Laura was treating my fence project like I had built a prison watchtower, and she was making sure every vendor, every neighbor, and every passing dog walker knew she was in charge. The fence itself was perfectly legal. I had checked the covenants 3 times before I hired the crew. The height limit was 6 feet, and mine measured 5 feet 11 inches. The setback rule was 3 feet from the property line, and mine was 3 feet 2 inches. The style had to be vertical pickets with no barbed wire or chain link, and mine was cedar planks with a clean cap rail. I even paid for a third-party surveyor to mark the line so there would be no question about where my property ended and the easement began. The surveyor report was sitting in my truck right now, dated and notarized, with photos and measurements that matched the county records. But Laura did not care about any of that. She cared about making an example of me, and she was willing to bend every rule in the book to do it. The whole mess started 3 weeks ago when I called the HOA office to ask for a fence approval form. Laura answered on the 4th ring and immediately asked why I needed a fence. I told her privacy and to keep my dog in the yard. She said the board would need to review my application, even though the covenants did not require board approval for standard fences under 6 feet. I said I would submit the form anyway, just to keep everything clean. She said fine, but it might take up to 60 days to process because they were very busy. That was the first red flag. The covenant said approvals for compliant projects should take no more than 15 days unless there was a specific written objection. Laura was already stalling, and I had not even submitted anything yet. I submitted the form the next day with all the required attachments: site plan, fence spec sheet, material list, and a letter from the surveyor confirming the setback measurements. I hand-delivered it to the clubhouse and got a date-stamped receipt from the front desk. Laura was not there that day, but the receptionist told me Laura handled all architectural requests, and she would be in touch. 2 weeks went by with no response. I called the office twice and left messages. No callback. I emailed the general HOA address and got an auto-reply saying someone would respond within 3 business days. No response. Finally, I went back to the clubhouse in person and found Laura at her desk. She looked at me like I had interrupted a state secret and said my application was under review. I asked what that meant. She said the board had questions about the height and the setback. I asked what questions. She said she could not discuss it until the board made a formal decision. I kept my voice calm and said the covenants were clear and my fence met every standard. She leaned back in her chair and smiled, the kind of smile that meant she knew something I did not. Then she said, I decide what counts as compliant, not you." That line stuck with me. It was the first time she said it, but it would not be the last. The next morning, I got a violation notice in my mailbox. It was printed on official HOA letterhead with the Riverstone Meadows logo at the top and a case number in the corner. The notice said I had installed a fence without approval, and the fence exceeded the height limit by 2 inches. It said I had 7 days to remove the fence or face a fine of $500 plus $50 per day until compliance. It said the board had reviewed photographic evidence and determined the violation was willful and flagrant. I read that notice 3 times before my brain caught up. I had not installed anything yet, the posts were not even ordered, the contractor was scheduled to start in 4 days. The photographic evidence could not exist because there was no fence to photograph. And the height claim was absurd because I had not built anything to measure. I called the contractor immediately and told him to hold off. He said he already had the materials staged and his crew was ready to go. I said I needed to sort out the HOA issue first, or they might try to force a stop work order in the middle of the job. He was not happy, but he agreed to wait. Then I drove back to the clubhouse and asked to see Laura. The receptionist said she was in a meeting. I said I would wait. 30 minutes later, Laura came out, saw me sitting there, and tried to walk past. I stood up and said I needed to talk about the violation notice. She stopped, turned around, and said there was nothing to discuss. The notice was final unless I wanted to file an appeal, which would cost $250 and take 45 days to schedule a hearing. I held up the notice and said the fence does not exist yet. She said the board had received a complaint from a neighbor about construction activity and they investigated. I said there has been no construction activity because I have not started. She said the board stood by their findings and I should contact an attorney if I disagreed. That is when I realized Laura was running a fake violation notice scheme with altered dates and recycled photos. She was backdating complaints and using old photos from other addresses to create a paper trail that did not match reality. And she was doing it because she wanted to control the process, bill me for fees, and force me to bow out or pay up before I even started. I acted like I was backing down because timing was the whole weapon. I told Laura I would think about my options and left. Then I went home and started building my case. I pulled the county property records, the original survey from when I bought the house, and the HOA covenants with the amendment history. I printed everything and started highlighting the relevant sections. I also called my next-door neighbor, a calm guy named Rick, who was tired of Laura and her selective enforcement games. Rick agreed to be a witness if I needed one, and he told me Laura had pulled the same stunt on another neighbor last year over a mailbox post. That neighbor had paid the fines just to make it stop, and Laura had pocketed the fees without ever fixing the supposed violation. 2 days later, Laura showed up at my house unannounced with a tape measure and a clipboard. She did not knock. She just walked into my front yard and started measuring the distance from my driveway to the property line. I was inside making lunch when I saw her through the window. I went outside and asked what she was doing. She said she was conducting an inspection to verify compliance with setback requirements. I said I have not built anything yet. She ignored me and kept measuring. She stretched the tape from the sidewalk to a point about 6 inches past where my property line actually was, wrote something on her clipboard and said, "This is a problem." I asked what problem. She said the fence posts would encroach on the HOA easement if I built where I planned. I said the surveyor already marked the line, and my posts will be 3 feet 2 inches from the property line, which is well within the setback. She said the surveyor was wrong and the HOA had its own measurements. I asked to see those measurements. She said they were proprietary and not available for public review. Rick was outside watering his lawn and watching the whole thing. Laura saw him and called over, asking if he had concerns about my fence project. Rick said no, it looks fine to me. Laura frowned and said the board would be interested to know he was not cooperating with the inspection process. Rick just shrugged and went back to watering. Laura stood up, folded the tape measure, and said I should expect another notice within 24 hours. Then she walked back to her car and drove off. I stood there, feeling my jaw tighten, knowing she was going to manufacture another fake violation and try to bury me in fees before I could even defend myself. That night, I got an email from an attorney named Philip Crane with a subject line that said, "Demand for immediate compliance." The email was full of bluff language meant to scare me into paying instantly. It said the HOA had documented multiple violations, including unpermitted construction, encroachment on common areas, and failure to respond to board directives. It said I had 72 hours to remove all non-compliant structures and pay accumulated fines totaling $1,250, or the HOA would file a lien on my property and pursue legal action for costs and attorney fees. I read that email twice and felt my blood pressure spike. There were no structures to remove, the fines were invented. The attorney was using boilerplate scare tactics to force a quick settlement before I had time to think. I forwarded the email to Rick and asked if he had ever seen anything like this. He wrote back within 10 minutes and said Laura did the same thing to him 2 years ago over a driveway repair. He paid the fine because he did not want the hassle, and Laura never followed up on the supposed violation. That email was the turning point. I realized Laura was not just being difficult. She was running an intimidation scheme designed to extract fees and punish anyone who questioned her authority. And I was her current target because I had the audacity to ask for documentation and follow the actual rules instead of her made-up process. I called the contractor the next morning and told him to proceed. He said, "Are you sure?" because the HOA is threatening to stop the work. I said I am sure, and if Laura shows up, do not engage with her. Just keep working and let me handle it. He agreed, but I could tell he was nervous. The crew showed up at 7 in the morning with a truck full of posts and panels. They marked the post locations with stakes and string line, double-checked the measurements against the survey, and started digging. By noon, they had 6 post holes dug and were mixing concrete for the first set. Laura showed up at 12:30. She parked on the street and walked straight into my yard without asking. The crew foreman saw her coming and looked at me. I nodded and said, "Keep working." Laura stopped about 10 feet from the nearest post hole and said, "This is an unpermitted construction site and all work must stop immediately." The foreman ignored her and kept leveling the post. Laura raised her voice and said, "I am ordering a stop work under HOA authority." The foreman finally looked up and said, "Ma'am, you need to talk to the homeowner." Laura pointed at me and said he does not have approval and this fence is illegal. I walked over and said the fence meets every requirement in the covenants, and I have a surveyor report proving the setback is correct. Laura said the surveyor report is not valid because it was not reviewed by the board. I said the covenants do not require board review for third-party surveys. She said I was interpreting the rules incorrectly, and the board had final say on all measurements. Then she pulled out her phone and took photos of the post holes, the string line, the crew, and me. She said these photos would be used as evidence of willful violation, and the fines would now increase to $1,000 per day until I stopped the work. Rick came outside and stood on his driveway watching. Laura saw him and said, "This does not concern you." Rick said, "I live next door, so yeah, it kind of does." Laura said the board would hear about his interference. Rick said good, because I have some things to say about selective enforcement. Laura walked back to her car and drove off. The crew kept working. By the end of the day, all the posts were set and the concrete was curing. The foreman said they would be back in the morning to hang the panels, and if the HOA tried to stop them again, he wanted me to call the police because he was not getting in the middle of a civil dispute. That night, I got another email from the attorney. This one said the HOA had filed an emergency complaint with the county and requested an inspection to determine if my fence violated zoning codes. It said the inspection was scheduled for the next morning at 9, and I was required to provide access to the property or face additional penalties. I called the county planning office first thing the next morning and asked if there was any inspection scheduled for my address. The clerk checked the system and said no, there was nothing on file. I asked if the HOA could request an emergency inspection without notifying me first. She said no, that is not how it works. Any inspection request has to go through the homeowner unless there is an immediate public safety issue, and even then, the county has to provide notice. So the attorney email was another bluff. Laura was trying to create the appearance of official action to scare me into stopping the work, but she had no actual authority and no inspection was coming. The crew came back at 8 in the morning and started hanging the panels. By noon, the fence was half done. By 3 in the afternoon, it was complete. The foreman walked the line with me and checked the height at every post, 5 feet 11 inches, exactly as planned. The setback was perfect. The panels were level. The gate swung smooth. It was a textbook installation, and I had photos and measurements to prove it. Laura showed up at 3:30, right as the crew was loading the truck. She walked the fence line with her tape measure and her clipboard, taking notes and photos like she was documenting a crime scene. Then she came over to me and said, "You will pay the fee, then you will pay the fee about the fee." That was the second time she said it, and it hit me just as hard as the first time. She was not interested in compliance. She was interested in punishment, and she was willing to stack fees on top of fees until I either broke or fought back. Rick was outside again, this time with his phone out, recording. Laura saw him and said, "You are creating a hostile environment by filming." Rick said, "No, I am creating a record." Laura said the board would take action against both of us. The crew finished packing and drove off. I stood in my yard with the completed fence behind me and the violation notices in my hand, knowing the next move was critical. That night, my kid brother called and said he was driving through Montana on his way to Seattle and could he crash at my place for a night. I said sure, I would love to see him. He said he would be there late tomorrow night and leave early the next morning because he had to be in Seattle by noon. That was when the time pressure kicked in. Laura had been escalating steadily, but now there was a deadline. My brother would be here for less than 12 hours, and if Laura decided to target his car, she could make his trip a nightmare. The next evening, my brother pulled into my driveway around 10 at night. He parked his car on the street in front of my house because my driveway was full. We stayed up late talking, and he crashed on my couch around midnight. I went to bed thinking everything was fine. At 6 in the morning, my brother woke me up and said there is a tow truck outside and a guy is hooking up my car. I threw on a hoodie and ran outside. Sure enough, there was a flatbed tow truck idling on the street with my brother's car halfway loaded. A guy in a reflective vest was working the winch. I ran up and said, "What are you doing?" He said he had an order to tow this vehicle for an HOA violation. I said this is visitor parking and there is no violation. He showed me a work order with the HOA letterhead and my address. The work order said the vehicle was parked in a restricted zone and blocking access to common areas. It was signed by Laura Stewart, records custodian, and dated the night before. I told the tow operator this is a visitor and he is leaving in 2 hours. The operator said he was just following the work order, and if I had a problem, I should call the HOA. I said the HOA does not have authority to tow a legally parked visitor vehicle without proper notice. He said the work order says otherwise. I asked to see his authorization paperwork. He said it was in the truck. Rick came outside and started filming again. The tow operator saw him and said, "You cannot film me." Rick said, "I am on my own property and you are on a public street, so yes, I can." I pulled out my phone and called the non-emergency police line. I explained the situation and said I believed the tow was not authorized. The dispatcher said an officer would be there in 10 minutes. The tow operator heard that and stopped the winch. He said he was not waiting around for the cops, and if I had an issue, I could file a dispute with the tow company. Then he unhooked my brother's car, dropped it back on the street, and drove off. My brother stood there in his pajamas and said, "What the hell just happened?" I said, "Welcome to Riverstone Meadows." The police showed up 15 minutes later. I explained the situation and showed the officer the work order. He looked it over and said the work order did not have proper authorization because it was not signed by a board officer, just a records custodian, and there was no evidence of a violation. He said I should file a complaint with the HOA and consider a restraining order if the harassment continued. He took photos of the scene and gave me an incident report number. Rick told the officer this was part of a pattern, and Laura had been targeting me for weeks. The officer said he could not get involved in a civil HOA dispute, but the incident report would be on file if I needed it for court. My brother left an hour later, shaken and annoyed. I apologized and said I did not expect Laura to go after a visitor vehicle. He said it was fine, but I should probably move. If you are enjoying this story, please hit like and subscribe for more wild HOA drama and satisfying justice moments. I spent the rest of that morning putting together my evidence file. I had the surveyor report, the county property records, the original approval form with the date stamp, the violation notices with their impossible dates, the attorney emails with their bluff language, the photos of the completed fence showing exact measurements, and now the incident report from the tow true, see key, encounter. I also had Rick's witness statement and his phone footage of Laura's tape measure stunt and the tow truck scene. But I still needed one more piece. I needed proof that Laura's actions were personal and not just bad judgment. I needed something that showed intent to make an example of me. That is when I remembered the board meeting. The HOA held open meetings on the first Tuesday of every month, and they were required to allow homeowners to speak during the public comment period. The next meeting was in 5 days. I marked my calendar and started preparing my presentation. But I also started working on a backup plan, because I knew Laura would try to shut me down the moment I stood up to speak. 2 days before the meeting, I got a text from a neighbor I barely knew. Her name was Janet, and she lived 3 streets over. The text said, "I heard what Laura is doing to you. Check your email." I opened my email and found a message from Janet with an attachment. The attachment was a spreadsheet with the header Compliance Targets. The spreadsheet had a list of addresses, names, and violation types. My address was highlighted in yellow with a note that said, "Fence Project." High priority. Make example. There were 4 other addresses on the list, all highlighted, all with notes like mailbox repair, stall and fine, driveway reseal, deny and escalate. The spreadsheet was dated 3 months ago, and it was saved in a folder labeled Board Strategy. Janet's email said, "I used to volunteer in the office, and I saw this file on Laura's computer. I made a copy because I thought it was wrong. I did not know what to do with it until I heard about your situation. I am sorry I did not come forward sooner." That spreadsheet was the trump card. It proved Laura was running a target list and using selective enforcement to punish homeowners who questioned her authority. It proved the violations were not about compliance. They were about control. I printed 3 copies of the spreadsheet and added it to my evidence file. Then I called Rick and asked if he would come to the board meeting with me. He said absolutely, and he would bring his footage and his witness statement. I also called Janet and thanked her. She said she would not be at the meeting because she was afraid of retaliation, but she gave me permission to use the spreadsheet as long as I did not mention her name. The night before the meeting, I rehearsed my presentation in front of the mirror. I practiced staying calm, speaking clearly, and hitting the key points in under 3 minutes because that was the public comment time limit. I also practiced pivoting if Laura tried to shut me down or derail the discussion. The meeting was held in the clubhouse community room at 7 in the evening. I got there at 6:45 with Rick. The room was set up with a long table at the front for the board members and folding chairs for residents. About 15 people were already seated. Laura was at the front table with 4 other board members. She saw me walk in, and her expression went cold. The board president called the meeting to order at 7 sharp and ran through the standard opening items: budget report, landscaping update, pool schedule. Then he opened the floor for public comment and asked if anyone wanted to speak. I stood up and said I would like to address the board about a fence approval issue and selective enforcement. Laura immediately raised her hand and said this item was not on the agenda and could not be discussed. The board president looked at her and said public comment does not require agenda placement. Laura said the issue involved pending legal action and should be discussed in executive session. The president said he was not aware of any pending legal action. Laura said the HOA attorney had been consulted. The president said, "Let him speak." I walked to the front of the room and started my presentation. I introduced myself, stated my address, and said I had installed a fence in full compliance with the covenants, but had been issued fake violation notices, threatened with liens, and harassed by the records custodian. I held up the surveyor report and said the fence met every height and setback requirement. I held up the violation notices and said the dates were impossible because the notices were issued before the fence was built. Laura interrupted and said I was misrepresenting the timeline. I said I had date-stamped receipts proving the timeline. She said I was in violation of multiple standards and the board had discretion to enforce as they saw fit. I said the covenants do not grant the board discretion to invent violations. Then I held up the spreadsheet. I said a former volunteer provided me with a document showing the HOA maintained a target list of homeowners for selective enforcement. I read the note next to my address. Make example. I said this proved the violations were not about compliance. They were about punishment. The room went silent. Laura's face turned red. The board president leaned forward and said, "Where did you get that document?" I said a concerned resident provided it to me because they believed the HOA was acting improperly. Laura stood up and said the document is stolen property and cannot be used. I said it is a public record created by an HOA officer and I have every right to present it. Rick stood up and said I have video footage of the records custodian conducting an unauthorized inspection and threatening the homeowner. He held up his phone. I also have footage of a tow truck operator attempting to tow a visitor vehicle based on a fake work order. The board needs to see this. The board president said this meeting is getting out of hand. Laura said the board should move to executive session immediately. One of the other board members, a woman named Sandra, said, "No, I want to hear this." The president sighed and said, "Go ahead." Rick played the footage on his phone, holding it up so the board could see. The first clip showed Laura measuring the fence line and claiming the surveyor was wrong. The second clip showed the tow truck scene with the operator admitting he had a work order signed by Laura. Sandra said this is a serious problem. The president said we will need to review this. Laura said the homeowner is manipulating the facts and the board should not make any decisions based on incomplete information. I said I have one more piece of evidence. I pulled out a small digital recorder and held it up. I said I recorded a conversation with the HOA attorney where he admitted the violation notices were not based on actual inspections, and the board was relying on the records custodian's representations without independent verification. I said I am happy to play the recording if the board would like to hear it. That was a bluff. I did not have a recording. But Laura did not know that, and the threat of an audio clip where she might have said something incriminating was enough to change the room's energy. Laura stood up and said this is harassment and defamation. I said it is transparency and accountability. The president said we need to take a recess and consult with the attorney. Laura said the attorney will advise immediate legal action. Sandra said the attorney will advise us to fix this before it gets worse. The board took a 15-minute recess. Laura stormed out of the room. The other board members huddled in the corner, talking in low voices. Rick and I stayed in our seats. A few other residents came over and said, "Thank you for speaking up. We have had problems with Laura too." When the board reconvened, the president said the board would launch an internal review of the records custodian's actions and suspend all pending enforcement actions against my address until the review was complete. Laura objected and said the board did not have authority to suspend enforcement. The president said the board absolutely has that authority and the motion is approved. Laura stood up, grabbed her papers, and walked out. The meeting continued for another 20 minutes, but the main event was over. After the meeting, Sandra came over and said, "I appreciate what you did tonight. This has been a problem for a long time and no one wanted to be the first to push back. I said I did not have much choice." She said you might have just saved this HOA from a lawsuit, because if you had filed, the insurance carrier would have found out about that spreadsheet and we would have lost coverage. That comment stuck with me. The insurance carrier. I had not thought about that angle, but Sandra was right. If the HOA's insurance company found out the board was running a selective enforcement scheme and creating liability exposure, they would drop coverage or demand reforms. 2 days later, I got a certified letter from the board president. The letter said the board had completed its internal review and determined that several violation notices issued to my address were not properly supported by documentation. The letter said all fines and fees were rescinded and the HOA would reimburse me for any costs I incurred in responding to the notices, including filing fees if I chose to pursue a formal complaint. The letter also said Laura Stewart had resigned her position as records custodian effective immediately. I called Rick and told him the news. He said that is great, but I bet Laura is not done. I said probably not, but at least the board is paying attention now. The next week, I got a call from Sandra. She said the board had received a letter from the HOA's insurance carrier. The carrier had been conducting a routine audit and discovered irregularities in the records custodian's files, including the target list spreadsheet. The carrier issued a non-renewal warning and demanded reforms within 30 days, or the association's coverage would be terminated at the end of the policy period. Sandra said the board was scrambling to implement new procedures and oversight. She said the carrier wanted documented approval processes, regular audits, and a formal complaint mechanism for homeowners. She said it was going to be a lot of work, but it was the right thing to do. I said, "Does this mean the insurance company is refusing to act without proper authorization?" Sandra said, "Exactly, and that is your payback." A tow vendor refusing to act without proper authorization forced the board to realize they could not just make up rules and hope no one pushed back. The following month, the board held a special meeting to approve new compliance procedures. The meeting minutes documented the changes and included a section on lessons learned. One line stood out: "The board acknowledges that selective enforcement policies undermine community trust and create legal and financial risks. Moving forward, all enforcement actions must be supported by clear documentation and applied consistently across all homeowners." That line was the boomerang. Laura had said, "I decide what counts as compliant, not you." Now the board minutes said the opposite. Laura's own selective enforcement got documented in the minutes, and it became part of the permanent record. I also found out later that Laura tried to fight the insurance carrier's demands. She sent an email to the board claiming the carrier was overreacting and the target list was just an internal planning document. The board forwarded that email to the carrier, and the carrier responded by saying any further resistance would result in immediate non-renewal. Laura backed down. Karen says it is about safety, and the insurer email says stop. That was the funny karma moment. Laura had spent weeks claiming her enforcement actions were about safety and protecting the neighborhood, but when the insurance carrier said stop, she had no choice but to comply. In the end, the HOA paid my filing fees to end the fight. I had prepared a formal complaint with the state HOA Oversight Board, and the HOA's attorney advised the board to settle rather than risk a public hearing. The board agreed to cover my costs, issue a written apology, and amend the covenants to include stronger homeowner protections. Rick and I celebrated with beers on my back deck. He said, "You really did it." I said, "We did it." He said, "No, you were the one who stood up first." I just filmed. I said, "Your footage was the proof we needed." He said, "Maybe, but you were the one who had the guts to walk into that meeting and put the spreadsheet on the table." We sat there for a while, watching the sun go down behind the fence. The same fence Laura had tried so hard to stop. The fence was perfect. 5 feet 11 inches, 3 feet 2 inches from the property line, vertical cedar planks with a clean cap rail. It met every standard in the covenants, and now it was part of the neighborhood, standing as a reminder that rules matter and enforcement has to be fair. I never saw Laura again. I heard she moved to a different HOA in a different part of town. I hope she learned something from the experience, but I am not holding my breath. As for me, I kept coaching, kept living in Riverstone Meadows, and kept my fence exactly as it was. The HOA never bothered me again. The new records custodian was professional and helpful. The board implemented the reforms and things settled down. The neighborhood was quieter, calmer, and a little less interested in measuring fences. I hope your neighborhood stays drama-free.